What could happen at a child's school if that child is referred for an offense to court? Any child of school age, being high school or under, is subject to certain rules that they must comply with while they're at school. If a child were to be accused of violating a law, either at school or not in school, oftentimes that is considered to be a violation of school rules. So what happens then? Well, if the offense happens at school, the school will know about it pretty quickly, and the school will take their course of action at that time. If the offense does not happen at school, the school will probably still find out. They'll probably still find out from the police department that investigates that case and ultimately either writes that ticket or sends the case to a juvenile court. So what happens is when a police officer refers a case to court, whether that's juvenile court or adult court, the police officer notifies the school district, the school administrator, that that child is being referred for an offense. That's a very beginning stage. The child hasn't been adjudicated of anything yet. They haven't been convicted. It's just notice to the school. But oftentimes that notification will trigger a code of conduct hearing at the school. What happens is the school will call the parents, the child, the attorney if they have one, and the school representatives, so a school attorney, a principal probably, the school resource officer maybe, different officials from the school, and we'll all meet together. What is discussed is basically, is there a reason to believe that this child committed an offense, and is that a violation of school rules? If it is, the child will probably be suspended for a period of time, usually between 30 and 90 days. At that time, they will go to either a D.A.E.P, a disciplinary alternative education program, or they will go to J.J.A.E.P, which is the Juvenile Justice Alternative Education Program. The difference is that the D.A.E.P is within that child's school district. The J.J.A.E.P is county. So that would be the county alternative school. As the case proceeds through court, the school may get another notification if the child is convicted, placed on deferred prosecution program, placed on deferred adjudication probation, or adjudicated in the juvenile court. At that point, it's the prosecutor's duty to inform the school district of that result within 24 hours from that result. It is also the prosecutor's duty to notify the school district if the child is required to register as a sex offender. Generally, that information goes in the student's file, and generally there's not another hearing to determine if the child should be expelled again, but it's just more information that's included in the file. The prosecutor also has to notify the school district if the prosecutor rejects the case for lack of evidence, or if the child is found not guilty of that offense. As the child moves through their disposition, whether that is probation or a conviction or deferred prosecution, there may be further notification to school by the probation department. This would happen if the child moves schools during their period of supervision. So if a child were on probation and they went to one school district at first, but then the family moved, or the family decided to take that child out and send them to a private school or something like that, then it would be the probation officer's duty to send another notification to the new school about the fact that the child is being supervised for an offense and what that offense is. Thanks for watching. If you enjoyed today's content, please like and subscribe. If you have any questions or comments, you can leave those down below. Otherwise, follow us at versestexas.com.